Hi, today I am going to share with you about the defense you must take or you must plan or you must submit to the court when a false civil case is filed against you. I am limiting this video only to the civil case. Now imagine A filed a false case against B, claiming that A gave 1 lakh rupees to B by way of a cash and B executed a promissory note for receiving the consideration of 1 lakh. This is a false case of A filed against B. Now how B should defend this claim of A? In civil rules of practice, there are rules drafted even how to defend. You cannot defend a civil case like the defense you take in a social conversations, in a friendly conversations, office arguments. No. Court has different rules of taking defense. Every defense you take in the court must be very comprehensive. Remember, it must not only be comprehensive, but it must include only the facts which you can prove, either by oral or documentary evidence. So you must not be emotional in submitting defense to the court. And you should be very careful in informing to the court only what is necessary. Unnecessary facts must be deleted from your submissions. In the instant example taken on hand, if A claims a false case, if A files a false case claiming that B is liable to pay 1 lakh rupees paid by A to B by way of a cash, and B executed a promissory note in return for receiving the consideration, the defense could be, if you become emotional, the defense will be that A is a fraud. Simple, A is a fraud. But that doesn't make out a best defense. Court will not consider that defense as the best defense. It is a defense, but undoubtedly it is not the best defense. It is a defense in brevity. When you take a defense, you must not leave any gaps. That is very important. If you leave any sort of gap, court will come to an implied conclusion. Court will presume that you left that gap deliberately. That is why pleading is an art. And you must not participate in the pleading, you must leave it to the advocate, because advocate knows what happens in the court. So the best way to defend the false case filed by A against B is to say that you don't know who A is, you don't have any relationship with A, you never received a single rupee of consideration, you never signed any promissory note, and finally A is a fraud. This becomes the comprehensive defense, unlike the earlier defense where you simply claim one of these 4 options. You may say you don't know A or you leave it there. You may say you did not sign the document and leave it there. You may say you did not receive the money and leave it there. You may say that A is a fraud and leave it there. But that is not sufficient in the court. So any defense you take in the court must be comprehensive. Don't leave any sort of gap while taking the defense. Hope I am clear with this example. You can apply this principle. This is the principle that is written in the Civil Procedure Code under Order 8, Rules 3, 4, 5 of Civil Procedure Code 1908. So the defense should be planned in such a way that you should not leave any gaps. Not only that, you should also defend in such a way that you must be able to prove everything. Either by documentary or oral evidence, you can prove. The point is, you must not leave any gap. Hope I'm clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.